5 seconds to go. Start. He should make a roving inquiry into the pros and cons of the matter and weigh the evidence as if he was conducting a trial. In the light of the decisions referred supra, it is thus obvious that it will be within the jurisdiction of the court concerned to sift and weigh the evidence for the limited purpose of finding out whether or not a prima facie case against the accused concerned has been made out. We are of the considered view that a caution has to be sounded for the reason that the chances of going beyond the permissible jurisdiction under section 227 CRPC and entering into the scope of power under section 232 CRPC cannot be ruled out, as such instances are aplenty. In this context, it is relevant to refer to a decision of this court in Om Prakash Sharma versus CBI. Taking note of the language of section 227 CRPC is in negative terminology and that the language in section 232 CRPC is in the positive terminology, and considering this distinction between the two, this court held that it would not be open to the court while considering an application under section 227 CRPC to weigh the pros and cons of the evidence alleged improbability and then proceed to discharge the accused, holding that the statements existing in the case therein are unreliable. It is held that doing so would be practically acting under section 232 CRPC even though the said stage has not reached. In short, though it is permissible to sift and weigh the materials for the limited purpose of finding out whether or not a prima facie case is made out against the accused on appreciation of the admissibility and the evidentiary value, such materials brought on record by the prosecution is impermissible, as it would amount to denial of opportunity to the prosecution to prove them appropriately at the appropriate stage, besides amounting to exercise of the power coupled with obligation under section 232 CRPC available only after taking the evidence for the prosecution and examining the accused. Even after referring to the aforesaid decisions, we think it absolutely appropriate to refer to a decision of the Madhya Pradesh High Court in Kaushalya Devi versus State of MP. It was held in the said case that if there is no legal evidence, then framing of charge would be groundless, and compelling the accused to face the trial is contrary to the procedure, offending Article 21 of the Constitution of India. While agreeing with the view, we make it clear that the expression legal evidence has to be construed only as evidence disclosing prima facie case, the record of the case, and the documents submitted therewith. The stage of section 227 CRPC is equally crucial and determinative to both the prosecution and the accused. We will dilate the issue further. In this context, certain other aspects also require consideration. It cannot be said that section 227 CRPC is couched in negative terminology without a purpose. Charge sheet is a misnomer for the final report filed under section 173(2) CRPC, which is not a negative report and one that carries an accusation against the accused concerned of having committed the offence mentioned therein. Stop.